Hello, video is part of a series of resources for Texas property owners. I'm Pat O'Connor with O'Connor & Associates, and the topic of today's video is, should you pursue binding arbitration if you got a raw deal at the Appraisal Review Board hearing? There's 3 steps to the tax appeal process in Texas: the informal hearing, the Appraisal Review Board hearing, also known as the ARB or formal hearing, and then finally either binding arbitration or a lawsuit in state district court. So you must go to the Appraisal Review Board hearing to be able to proceed with binding arbitration. Binding arbitration is available for both real estate and business personal property, and the limits for binding arbitration are up to $3 million for any property other than a homestead. So this is the value after the ARB, can be up to $3 million for any property other than a homestead, and there's no limit on the value for a property that is a homestead. We did one property this year in binding arbitration that was valued at $20 million, over $20 million. So conceivably you could have a homestead valued at $1 billion and do binding arbitration. The binding arbitration can be on either market value or unequal appraisal. And the great thing about binding arbitration is it's the first time that you have a venue where the property owner gets a fair hearing. The reality is the Appraisal Review Board hearings are tilted in favor of the appraisal district for whatever reason, but it shouldn't be that way, but that's the way it is. So with binding arbitration, you finally get a venue where there's a level playing field. Also, it's the first time that the appraisal district is forced to really consider unequal appraisal, since most appraisal review boards simply just ignore unequal appraisal. There is a $450 deposit for accounts up to $500,000 in value. It stair-steps up from there, but for accounts up to $500,000 in value, there's a deposit of $450. And $50 of that is retained by the Texas Comptroller as a processing fee, and the other $400 is returned if you win the binding arbitration case, and it goes to the arbitrator if you don't win the binding arbitration case. So whether you win the case or not is determined by the arbitrator's decision. If you request the value here and the ARB value is here, you win if the arbitrator's value conclusion is closer to your value than it is to the Appraisal Review Board value. So your fee, the $400, is returned if you win the case, but it's not returned if you don't win the case. So we would strongly encourage you to pursue binding arbitration if you have a good case after the Appraisal Review Board. However, if you're reluctant to put up the $450 deposit, O'Connor & Associates is the only large Texas firm that pays the binding arbitration deposit for our clients. And this is regardless of whether we win or lose the case. Even if we lose, you don't have to pay the binding arbitration fee. It's on our dime. So there's no risk with O'Connor & Associates for binding arbitration. So if you think you have a great case, please give us a call. We're looking for a limited number of great cases to pursue in binding arbitration. So if you think you have a great case after the ARB, give us a call at 800-270-2720, 800-270-2720. Otherwise, visit the Texas Fairness Checker at cutmytaxes.com. You'll find out in less than a minute if you're fairly taxed or not. This is Pat O'Connor with O'Connor & Associates. We'll be back soon with another tip.